Before we get to the court, and to the children, and to the day in May when 9 men spoke with one voice, we need to understand the idea they were up against. Because it was old, older than almost anyone arguing the case. The idea had a name, separate but equal. The doctrine, as best anyone can trace it, was born in Massachusetts. Not in the South, where we tend to imagine it, but in Boston, in the year 1850. A case called Roberts versus the City of Boston, in which the court upheld the practice of sending black and white children to separate schools. Here is the first irony of many in this story. Massachusetts did not keep that practice for long. Just 5 years later, in 1855, the state abolished segregation in its Boston schools. The place where the idea was born had abandoned it within a decade. But the idea itself did not die. It traveled. 13 years after that, the nation amended its own constitution. The year was 1868, and the 14th Amendment carried a promise written in plain and sweeping language, that no state could deny to any person within its jurisdiction the equal protection of the laws. Equal protection. Those two words would come to sit at the center of everything that followed. But a promise on paper is one thing. What it means in practice gets decided case by case, year by year. And the doctrine of separate but equal did not truly arrive in the Supreme Court of the United States until 1896, in the case of Plessy versus Ferguson. There, the court gave the idea its constitutional blessing. Separate facilities for the races were permissible, the court held, so long as they were equal. And so the doctrine became the law of the land. Think about the span of time here. From Plessy in 1896 to the case we are following, 58 years would pass. 58 years in which separate but equal was not a fringe theory or a regional habit, but the settled command of the nation's highest court. Generations of children grew up and grew old inside it. Now the doctrine touched many things: railroad cars, restaurants, drinking fountains, courtrooms. But the case before us narrowed the lens to one institution in particular, the public school. And to understand why the school mattered so much, you have to understand what the court believed a school to be. By the middle of the 20th century, education was no longer a luxury or a private affair. It was, in the court's eyes, the very foundation of good citizenship. The place where a child was prepared for professional training, for military service, for the basic business of being a person in the world. The state had taken this duty upon itself. And once it had, the court reasoned it could not hand that duty out unevenly. Chief Justice Earl Warren put it this way, and the words are worth hearing exactly as he wrote them. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms. A right which must be made available to all on equal terms. That phrase, on equal terms, is the hinge the whole case turns on, because the question was never really about buildings or budgets. It was about what the word equal could be made to mean. And to test that word, the court did not stay in the realm of doctrine and philosophy. It went looking for actual children. To understand what the court was deciding, you have to leave the world of doctrine for a moment and go to Topeka, Kansas. Because behind the citations and the Latin phrases were children. Black elementary school children who lived in a city that ran 2 sets of schools, one for white students and one for them. Kansas had not been ordered to segregate its schools. A state statute simply permitted cities of a certain size to do it, and Topeka had chosen to. So when these children were turned away from the schools nearest their homes, the schools their white neighbors attended, it was not an accident of geography. It was the deliberate operation of the law. The families went to court, and here is something that gets lost in the way we remember this case. Brown versus Board of Education was not one lawsuit, it was 4, gathered from 4 corners of the country and argued together. Kansas, South Carolina, Virginia, and Delaware. The facts in each were different. The schools, the towns, the precise injuries varied, but the legal question underneath them was identical, and so the court consolidated them under a single name, the name of a case from Topeka. Different children, different states, one question for all of them. Now here is where the story turns on itself. When the Kansas case was first heard, a three-judge federal panel listened to the evidence, and it made a finding of fact, not an opinion, a finding, something the court declared to be true based on what it had seen and heard. The Kansas court wrote, in language the Supreme Court would later quote back word for word, and I want to read it exactly as it stands, using the terms of its time. Segregation of white and colored children in public schools has a detrimental effect upon the colored children. The impact is greater when it has the sanction of the law, for the policy of separating the races is usually interpreted as denoting the inferiority of the Negro group. A sense of inferiority affects the motivation of a child to learn. Read that again in your mind. The court that heard this case found, as a matter of fact, that segregation damaged these children, that the harm was worse precisely because the law endorsed it, and then that same court ruled against the children anyway. Why? Because the judges believed their hands were tied. The schools in Topeka were, by the measurable standards of the day, roughly equal. Comparable buildings, comparable teachers, comparable books. And under Plessy versus Ferguson, equal facilities were all the Constitution required. The harm the court had just described was, in the eyes of the law as it then stood, irrelevant. So the contradiction sat there in the record. A federal court had documented the injury and then declined to cure it because the doctrine it was bound to follow had nowhere to put that injury. When the case reached the Supreme Court, that finding was waiting. The lower court had, in a sense, already written the most damning sentence in its decided Brown after the first argument, in the winter of 1952. It chose not to. Instead, in a decision that caught the lawyers on both sides off guard, it asked them to return a year later and argue the whole case over again. And it told them precisely what it wanted them to argue about. The question the justices handed back to the parties was a question about history. When Congress framed the 14th Amendment in 1868, and when the states ratified it, what did they understand it to mean for public schools? Did the men who wrote the promise of equal protection intend for it to reach into a classroom and forbid separating children by race? So the lawyers became historians. They came back in December of 1953 carrying the record of the Reconstruction era, the congressional debates, the votes, the school laws on the books in the states at the time. Each side read that record to prove its own case, and the court took all of it in. But when the justices sat down to weigh what that history actually established, they ran into an uncomfortable wall. The sources, they concluded, cast some light, but not enough to resolve the problem in front of them. In the end, they reduced everything history could offer to a single word. Inconclusive. Think about what that admission meant. The court had gone looking in the past for an answer, and the past had refused to give one. The intentions of lawmakers dead for the better part of a century could not tell these 9 men whether segregated schools were constitutional in 1954. So the court did the thing that still defines this opinion. It stopped looking backward, and it turned to the children standing in front of it. The justices refused to decide the case as though it were still 1868, or even 1896, when Plessy was written. Public education, they reasoned, had to be judged by the place it actually held in American life in 1954. And measured against the present, not the past, the court saw something that separate but equal had spent 58 years refusing to admit. To separate black children from white children by force of law, the court found, sent those children a message. It told them they were not fit to learn alongside the others, and a child absorbs that message early. The justices leaned on a body of psychological research that had grown up in the decades since Plessy, work by scholars like Kenneth Clark, gathered in footnote 11 near the close of the opinion. That research had given the injury a name, and now so would the court. The justices described the harm not as something done to a child's schooling, but as something done to the child. Chief Justice Warren set it down in a single sentence, one that would be quoted for the next 70 years. To separate them from others of similar age and qualifications, solely because of their race, generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. A feeling of inferiority, in their hearts and minds, in a way unlikely ever to be undone. The court was no longer talking about buildings or books or the pay of teachers. It was saying that separation itself, stamped with the authority of the state, inflicted a wound that no equal facility could ever heal. That was the answer to the question the entire case had been built around. And once the court had said it plainly, only one thing was left to decide: what the law would now demand. The 17th of May, 1954. The cases had been argued once, in December of 1952, then ordered rearged a year later. Now, after 18 months, the court was ready to speak. Chief Justice Earl Warren delivered the opinion of the court, and the most important word in that sentence may be the smallest one. The opinion of the court, not a plurality, not a bare majority with bitter dissents trailing behind it. One opinion, 9 justices, no dissent. A unanimous court speaks differently than a divided one. On a question that reached into every segregated classroom in the country, there would be no dissent for opponents to rally behind, no separate opinion to mine for doubt. The 9 spoke as one. That in itself was a kind of message. The opinion worked its way through the history of the 14th Amendment, through the meaning of public education, through the findings of the lower courts. And then, near its end, it reached the sentence the whole case had been built to hold. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Inherently, not unequal because the buildings were worse, or the books older, or the teachers paid less. Unequal in their very nature. Equal funding could not cure it because the inequality was the separation itself. With that, the doctrine that had governed American life since 1896 was finished, at least inside the schoolhouse. Plessy versus Ferguson had held that the law could keep the races apart, so long as it kept them equal. The court now ruled that, in education, those two promises could never both be kept. It is worth being precise about what the court did that Monday, and what it did not do. It reversed the lower courts in Kansas, in South Carolina, and in Virginia, where black families had been turned away. In the Delaware case, where the children had already won admission, it affirmed. In each, it struck down separate but equal in public schooling. That much was settled, and settled by all 9. What it did not do was say how. The court had declared segregation in the schools unconstitutional. It had not ordered a single child admitted to a single school. The hardest question, the question of remedy, of how you actually take a segregated system apart, it set aside. In a footnote, the court restored the cases to its docket. It asked the parties to return and argue not whether segregation was lawful, that was decided, but what should be done about it. The decree, the enforcement, the timeline, all of it would wait. The law of the United States had lived with a single phrase. 3 words that decided where millions of children would sit and learn and grow up. Separate but equal. The promise inside those words was that separation cost nothing. The same books, the same teachers, the same chance, only in different buildings. In 1954, that promise reached the Supreme Court. The justices reduced the entire case to one question and answered it. Chief Justice Earl Warren wrote, quoting the opinion directly. We come then to the question presented. Does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? We believe that it does. The court had